Howdy, y'all. You're listening to The Fixed Star. My name is Sam Bass. I'm once again joined by my co-hosts, Jacob David Glenn and David L. Hudson Jr. Today, we're taking a second look at the Supreme Court case Mahanoy Area School District v. BL, as a ruling just came out this past week. If you want a background on the cases and the cases that led up to it, we discussed this in our first episode, The Future of School Censorship. In this episode, we're going to be looking at the court decision and opinions to understand the ruling and also talk about the implications for students' freedom of speech going forward. Thanks for tuning in.
So we are back again talking about Mahanoy. The verdict came down middle of last week. And we talked about that case in the context of some historical cases, in the context of Tinker, and in the context of Barnett, as we'll inevitably be mentioning those again. But today we're going to review, and Sam's going to discuss the facts, tell us what happened of that case. So Sam, if you want to kick it off.
Yep, sure. Just a brief overview. We're talking about Mahanoy Area School District, VBL, who's a minor. And basically what happens is there's a high school student who is already a part of the JV cheerleading team, tries out for the varsity cheerleading team, does not make it. The following Saturday, off school campus, sends out a Snapchat with some vulgarity expressing her frustration. And then once the school administration finds out about it, they kick her off of the cheerleading team altogether. And then the parents decide to try and get this decision reversed. They don't have any luck, so then they take to court, where eventually it finds its way all the way to the Supreme Court. And just this last week, they ruled in the favor of the student, saying that it was against the First Amendment for the school to punish the student by kicking her off the team.
And so reading through the court's opinion written by Justice Breyer, it's a great ruling, I think, in my perspective. I know we all three agree, but it was somewhat more narrow than it could have been, and that's some of the opinions I've heard from various folks talking about it in podcasts and writing and conversation. It could have done a lot more, but it did protect BL in this instance. And one thing that I thought was interesting is they said that they're going to leave for future cases to decide how different things might play out in different contexts. And so they really did. It seems like whether they explicitly intend to or not, there's going to be some more of these student speech cases dealing with off-campus speech upcoming. But this is definitely a strong ruling. And I want to look at a few of the things Breyer said about his ruling. So he looked at a few factors. He said one thing he pointed to is that a school in relation to off-campus speech will rarely stand in loco parentis, and in loco parentis being essentially operating in the place of parents, serving that function of parents. And so he's looking at not universities, but high school, middle school, elementary school, saying that the school does have an interest in looking over the conduct of students and also maintaining order for the purpose of education. But this does establish a clear tendency. It's the beginning of a tangent pointing towards not involving the schools in off-campus speech. Now, how far that's going to go, that remains to be seen, and how bright of a line that is definitely, I think, an issue that's going to continue to be challenged, discussed, etc. Another of the important reasons that Breyer looked to is that he said, second, from the student speaker's perspective, regulations of off-campus speech, when coupled with regulation of on-campus speech, include all the speech a student utters during the full 24-hour day. So looking at that and saying we could have a whole students' whole days on our hands here. And so again, that kind of ties somewhat into that first point, but basically saying, look, we can't be monitoring kids all day. It's not tenable. And third, one of the underlying reasons Breyer looked at is he said the school itself has an interest in protecting a student's unpopular expression, especially when the expression takes place off campus. And right after that, he said words that I think are going to be cited frequently. America's public schools are the nurseries of democracy. And that reminds me of our first podcast, our first discussion. We talked about Barnett, where Justice Jackson wrote that schools serve the function of educating the young for citizenship. I feel it's almost it's rephrased, but kind of a very derivative of that line, and really bolstering that perspective. So with those three things, those three kind of underlying guideposts in line, he then proceeds into analyzing and applying the reasoning to this specific case. And I'll let David talk a little more about that.
Yeah, so the first feature that Breyer mentioned, as Jacob said, was that school officials often don't act in loco parentis when students are speaking off campus. And what Justice Breyer said in applying the facts to this case is there's no facts that indicate that Brandy Levy's parents delegated authority to school officials to discipline her for speech that she utters on a Saturday afternoon outside the Cocoa Hut, the convenience store, right? That if anybody should discipline Brandy Levy for that speech, it's her parents, not school officials. With regard to the second factor, she did say this on Saturday, right? And there's a real concern about this sort of 24-hour Big Brother pervasive monitoring of what students do. And school officials couldn't do anything if they had to punish students for everything that's posted on social media, right? There has to be some dividing line. And then, look, I mean, her speech was not exactly the most articulate. I find it quite ironic, Sam and Jacob, that, she used the F-bomb quite a bit in her Snapchat. It's 50 years ago that the United States Supreme Court decided Cohen v. California, the F the draft case. And now 50 years later, we've got another case. And what Breyer says is, look, it wasn't great speech, but sometimes we have to protect the superfluous, can't say that word right, superfluous, in order to protect the necessary, right? That the First Amendment protects a lot of offensive, obnoxious speech, right? That's a bedrock principle of the First Amendment. And so all three of those factors essentially indicate that the regulatory interest on the part of school officials was weak, that this idea of this anti-vulgarity interest just simply wasn't strong enough to overcome the freedom of expression. And then it's also important to realize that an alternative holding of the Third Circuit below was the Tinker test itself, right? That Brandy Levy's Snapchat did not cause a substantial disruption. And that's what Justice Breyer also indicated, right? There was no evidence in the record. In fact, there was evidence to the contrary that Brandy Levy's Snapchat did not cause a substantial disruption. But what I think is very significant is that this is the first case since Tinker, the first major Supreme Court case since Tinker that went in favor of the student. Right, because we had Bethel School District versus Frazier in 1986, Hazelwood School District versus Kuhlmeyer in 88, Morse v. Frederick in 2007. All of those were Tinker carve-outs. All of those were against the student and in favor of the school. And what do we have here? We have a Supreme Court opinion that reaffirms the vitality of Tinker itself. And that's significant.
That's a pretty interesting observation, and then also coupled with drawing the comparison to Cohen. So for those who might not know, the Cohen case is the F the draft jacket that the guy wore into a courthouse, right, David?
Yes, absolutely.
Yeah, he wore into a courthouse and was rung up on like a disturbing the peace or something like that. What was
breach of the peace. Mm-hmm.
Breach of the peace, right? And so, and the court said it was not a legitimate charge. The First Amendment wouldn't allow that. So it's interesting that speech kind of ends up getting lionized, the F the draft, and the same thing is happening to the student speech here, I mean, I think the I don't know if it was the ACLU themselves who put these shirts out, but I saw some shirts that said F cheerleading, F softball or whatever it was. And it's just funny because now the exact opposite thing ends up happening. That speech gets lionized, even though if we're reasonable minds sitting down, that's not great to have teenage girls saying that kind of stuff, or anybody saying that stuff. I don't mean to make it about anyone specifically, but it's just funny how the exact opposite intention, the exact opposite consequences of what was intended to happen. Whereas if they just kind of ignored it, it would have been nothing, never thought of or heard of again. But yeah, thanks, David. So Sam, do you want to mention anything about Alito's concurrence?
Sure. Yep. There's a couple things that we pulled out from Justice Alito's concurrence. The first quote was about how the public schools have a duty to teach students that freedom of speech, including unpopular speech, is essential to form our self-government. And then the other one was having to do with parents do not implicitly relinquish all that authority when they send their children to a public school.
Right, and so that's referring to, again, the in loco parentis argument. Like the parents still have some say over guiding their kids, particularly, again, outside of school. But then I think that's Alito also harping on that, saying the same thing as the schools are nurseries of democracy. I mean, I think he's, we're, as Jackson wrote, educating the young for citizenship. I think he's tapping into that underlying axiom there as well.
And I think we kind of got into it a little bit in the first one, but maybe this is a little too naive and generous of the school's time, in my opinion. But like, this could have just been a learning opportunity, right? Like, you have a student who, in my opinion, says the wrong thing and makes a mistake. And this could have been a learning opportunity to say, hey, like, this is what we say and what we don't say and why. You have a teenager who's learning how to be a human, learning how to join society. And instead of turning it into a teaching opportunity like you would at a school, you just remove like the thing that they enjoy and obviously that they cared about, right?
Yeah, and then also, I know all three of us played high school sports and have been in high school locker rooms, and that would be on the more mild side of anything I've heard in high school locker rooms, if my recollection serves me properly. So, yeah, I mean, I suppose I agree, but it's yeah, I think we're just going to continue to see these kind of things pop up. So on that note, I want to go back to the main opinion and read something. I read a bit of it, but I want to kind of put it in the context of the full paragraph, where Breyer writes, given the many different kinds of off-campus speech, the different potential school-related and circumstance-specific justifications, and the differing extent to which those justifications may call for First Amendment leeway, we can, as a general matter, say a little more than this. Taken together, these three features of much off-campus speech, the three things mentioned earlier, mean that the leeway the First Amendment grants to schools in light of their special characteristics is diminished. We leave for further cases to decide where, when, and how these features mean the speaker's off-campus location will make the critical difference. So Hudson, with the significantly more illuminated perspective, what do you take from that? I mean, do you think that's the court inviting or indicating that they're going to be willing to take more cases to litigate specific issues upcoming on this?
Absolutely. See, the Third Circuit below issued a categorical ruling that Tinker didn't apply at all to off-campus online speech. And the United States Supreme Court was not willing to go that far. In fact, Breyer says that schools do retain some regulatory interest over certain types of speech, and he specifically mentions harassing speech, cyberbullying, threats, etc. So it's going to take future cases to determine what the rule is in a true cyberbullying case, in a harassment case, in a threat case, or in some case in which the online student speech has a really close connection to like a school assignment or something like that. So it's definitely going to take a lot more litigation and it'll first take place in the lower courts, and then ultimately it'll be back up before the justices.
So here's a kind of a layman's question from, I'm not legally trained. Seeing a Supreme Court ruling and it not turn into like a precedent or something that can be used further, like what? I mean, I guess you kind of just went into it, but
oh yeah,
how does that happen?
No, this will be key precedent. So what this is going to do, I think, is it's going to cause a lot of school administrators to back off in close cases and say, well, we're not going to be disciplined students in the vast majority of these cases. It's going to have to be harassment, bullying, or threat, or some sort of connection to the school assignment. Breyer's features that Jacob went over are going to be the lodestars for litigating all the future cases. And as he said, it's very mushy. It's not as definitive as some would have liked, but there's a lot of good material in there that's going to be used by that's going to be added to the toolbox of a lot of First Amendment lawyers.
I've heard some interesting commentary on the case. I can't remember. It was from one of the more right-leaning political commentators I listened to that thought this was an absurd ruling, thinking that the school certainly should have the right to regulate foul language in this manner. And I found that very surprising, particularly because contemporary conservatives are a bit more concerned about their political speech being censored. And so it struck me as somewhat short-sighted that I've heard a lot of folks on the right, on certain aspects of the so-called right, critical of the way this ruling came out. And I suppose that comment leads nicely into looking at Thomas's dissent, because the way he wrote the first paragraph of his dissenting opinion was very, I mean, I guess you would say it's pithy almost. He wrote it just plainly stating the facts of the case, seeming to think that anyone who would read that would see that he's trying to point out how absurd this ruling is. David, you and I talked briefly, but I know you have some hot sports opinions.
So we knew that Clarence Thomas was not going to vote for the student, right? Clarence Thomas is the justice who wrote a concurring opinion in Morris v. Frederick, the 2007 case known as Bong His for Jesus. And in that concurring opinion, Justice Thomas called for the overruling of Tinker, that students really don't have any First Amendment rights to speak of. And so it's no surprise that Thomas went against the student here. He pulled out his favorite case in all of the history of student speech, an 1859 Vermont decision called Lander versus Seaver. And that's a case involving an 11-year-old student named Peter Lander Jr., who's walking down the road outside of school, and he sees his teacher, A.B. Seaver, and he yells out, old Jack Seaver, making fun of him. And the next day, Jack Seaver whips him with a rawhide. And so Lander and his father then sue, and the Vermont Supreme Court rules in favor of Seaver, the teacher, and essentially said that Peter Lander's obnoxious speech delivered off campus to his teacher could have a deleterious impact or harmful impact on school discipline, and therefore it was within the purview or within the ambit of school authorities to discipline him. And that's essentially what Thomas is saying. I didn't find Thomas's dissent here as obnoxious as his concurring opinion in Morse, because there's a little bit of language here where he seems to say, well, perhaps there are instances where we shouldn't follow the general rule, but the majority didn't do the job here, and he basically criticizes the majority opinion. But it's no surprise that Justice Thomas did not rule in favor of Brandy Levy.
That's pretty wild. So I wonder how Mr. Seaver would have received BL's speech.
That's right. He would not have liked it.
Yeah, man. So that's interesting. So in Tom, I guess I didn't know much about that case, honestly. But so the court, he writes, the court in the Mahanoy opinion overrides precedent without even mentioning 150 years of history supporting the coach. And so as you
Well,
mentioned, he's pointing towards
if
that.
you want to learn more about Lander versus Seaver and a lot of these cases, may I humbly suggest to the listeners out there, Jacob can vouch for it, Let the Students Speak, A History of the Fight for Free Expression in American Schools. It needs to be updated, but it's published in 2011, and it covers a lot of the cases, and it's a good read.
It is. I
Thank
can
you.
vouch for that. I actually have a signed copy, so I can. Yeah. But so definitely a great book. But what I was going to ask is, he says 150 years of history. I guess he's pointing to that case. But how was that case applied frequently in the years since? How significant was that case in the time from then until now?
It was a fairly significant case. As a state high court, it's one of the few that were decided that led to published opinion. It certainly wasn't the only one. I think the reason he likes it is because it involves saucy and disrespectful language, and it was speech off campus. A lot of the cases involved speech on campus, but there's quite a few of different state cases. These cases were usually brought in state court as opposed to federal court. Most of them today are brought in federal court, as you know. But it was a pretty significant case back in the day. But it's a case that was decided before the ratification of the 14th Amendment. It was a case decided before the incorporation of freedom of speech in 1925. And it certainly was decided way before we got Tinker versus Des Moines, where the court held that it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate.
Right on. Well, I think that's a great place to stop. Once again, this has been the Fixed Star. Thanks so much for listening with us, and we will see you next time.